Interesting legal question coming from the Attorney General Eric Holder this week. He says state attorneys general need not defend laws that they believe are discriminatory. Now, Holder's comments would seem to carry the most weight in cases like, for example, same-sex marriage, where some AGs think their state bans are discriminatory. But does Holder's position have any legal standing, and can DAs or others simply skip defending some laws if they do find them discriminatory? I mean, take, for example, what's going on in Arizona right now. In all likelihood, the governor is going to veto it. But let's say she doesn't. And let's say the Attorney General, as I would hope, would say, my gosh, this smacks of so many things that are wrong. Are we going down a dangerous path here if basically Attorney Generals can say, I like these laws, I don't like these laws? I mean, is that really what we're empowering or electing them to do?
They already do it. And the reality is that adultery is still on the books in New York. Nobody gets prosecuted for adultery. There are a host of laws that are on the books that people just don't get prosecuted for. And then there are others where they take a zero tolerance, or they set a restrictive policy with respect to plea offers. For instance, DWI in Westchester County, if you're above a 0.16 for your blood alcohol, you're going to be held as charged for the DWI, where some other counties they don't. So a lot of it's going to be the individual policy of the particular prosecutor's office. But again, if something comes up and you see a law that you believe is clearly unconstitutional, the question is, should you still prosecute that case? And you look with marijuana, for instance. Lots of prosecutors' offices do not bring simple marijuana cases anymore.
But take, though, I mean, you brought up, for example, adultery, and that's one of those old laws in the books that people either don't even know about or don't even really do. But Mark, take a piece of legislation that made its way through the legislature, okay, or was a ballot initiative, so the voters even voiced, for the AG to say, you know what, that's stupid, or you know what, I'm not going to enforce it because I don't really think that's legal.
To me, this raises more of the specter of Big Brother than what we were talking about in the last block, because it's not the Attorney General of the United States' prerogative to be telling state attorneys general which laws to prosecute and which laws not to prosecute. It violates every notion of federalism that you can think of. He's entitled to his opinion.
But it sends the wrong message.
And it absolutely sends the wrong message for the chief law enforcement authority in this country to be openly encouraging state prosecutors to nullify the law. That's wrong.
Is the rule of law, or is it fungible?
It is the rule of law until it is deemed not to be. And the point is, if you
By whom?
Well, if the legislature, you said it before, the legislature passes a law, you are duty-bound to enforce that law. And if you do not believe it's constitutional, you can bring an action, you can sue to have it deemed unconstitutional. What about the guy who's falsely arrested and he knows, because he's a lawyer, he knows he's being falsely arrested? Can he say, you know something, I know I'm being falsely arrested. I know you're violating my constitutional rights, I'm going to resist. Of course not. That's not the way it works. That creates, anarchy. That creates a situation that is untenable. And for the chief enforcement officer of the United States to basically be telling attorneys general, if you don't believe it's right, don't enforce it, don't defend it, is wrong. There's a procedure that we get told all the time.
Well, it trenches on the separation of powers. If you don't think it's constitutional, a judge determines whether the law is constitutional, not Eric Holder, not the Attorney General. And this is why the California counterpart to the DOMA case was bounced out of court on the lack of standing. If he doesn't defend the law, the states don't necessarily have the authority of Congress to hire a private lawyer to do the defending. The law freezes, and it's effectively being subverted by a
Even if I agree with him on a policy
body.
level now,
That's
I'm talking about the Attorney General, and I happen to, isn't he wrong because of the potential consequence? Let's say it's Attorney General John Ashcroft, okay? Let's flip this around, and all of a sudden, he believes that states that want to recognize same-sex marriages, that they're overstepping their bounds. And he's telling AGs, you know what? Don't listen to what the electorate or what the legislature has to say. Do what you think is right here. I mean, we'd be going hue and cry over that.
I think that it's a gray area, and you're right, because people tend to like it when the Attorney General is of their party or they share that perspective, but there's always someone who disagrees and will one day be in that seat and be able to do the exact same thing with laws that that you would like.
And that's a separation of
And
powers.
it's a
That's
separation.
exactly why this
However,
can't happen.
However, if you were to look at states' rights and you start to talk about separation of power, there'd be some states where African American people can't vote. There'd be some states where women couldn't vote. There'd be some states where, apparently in Arizona, where you could be denied the ability to go to a restaurant because of your marital status or your sexual orientation. So at some point, I think that you should be able to look at those extreme cases and say, look, this is clearly unconstitutional. And every prosecution's office has discretion about what cases they pursue.
Listen, George Wallace thought Brown versus Board was unconstitutional. So if you turn it on its flip side, George Wallace said, okay, I don't think this law is constitutional, so we're not going to have integrated schools in this country, and I'm a state attorney general, and or my state attorney general isn't going to enforce it, and that's what you get.
But there's a procedure pursuant to which you can stay the enforcement, even though a law is enacted. You go to a judge and you say, Judge, we clearly have a likelihood of success on this constitutional challenge. We're asking for injunctive relief so that the law does not go into effect until that issue is decided. You're absolutely right about that. But there's a way to stop it without creating a situation where one side will say something, then a new administration will come in and say something else.
But one example of this is the death penalty. So, for instance, prosecutors always have the discretion. You're never required to seek the death penalty, but you have the discretion to pursue it. So at some point, again, when is it prosecutorial discretion, and when is
on
it
that
saying you're
uplifting
ignoring
notice, we talked about the death penalty. That is all the time that we have here tonight. I want to hear how that ended here. Gentlemen.
Listen, I went to visit somebody in death row in Pittsburgh yesterday, so I've got
Good
death
time.
on the brain.
Good time. Gentlemen, thank you very much. We will see you all here tomorrow night, 6 p.m.